All right, hi everyone. Today I'm going to answer the question on the Amy Howard and Kenneth Howard versus Kerzner International Limited um, question of whether or not should the court have dismissed the case for transfer to the Bahamas on the basis of forum nonconvenience. In this particular case, there were two plaintiffs, Amy and Kenneth Howard. Amy Howard, for all intents and purposes, is the primary plaintiff in that she alleges that she contracted the ciguatera fish poisoning while on vacation in the Bahamas. She alleges negligence on part of um, the defendants that ultimately resulted in her suffering damages. Her husband, Kenneth Howard, alleges a loss of consortium, which in legal terms means that their marriage has suffered as a result of her condition, and her ability to be a companion to him has substantially diminished. The court reasons that it was proper to dismiss the action against Kenneth Howard on the basis of the forum selection clause. In other words, the court reasoned that in light of the evidence presented by both parties, it was undisputed that Kenneth Howard had an opportunity to review the forum selection clause. He signed the documents checking them into the resort. At that time, he was presented with the guest registration papers. These papers contained the forum selection clause, and he signed them without protest. Excuse me. Kenneth Howard had a meaningfully opportunity to consider and rejecting the terms of the forum selection clause, and he signed it. It is immaterial as to whether or not he actually took the time to read the document. All that matters in this particular instance is that it was provided to him. He had an opportunity to review the document, and he still chose to sign. The operative effect of the motion to dismiss, as it pertains to Kenneth Howard, is that any claim he wishes to bring would have be brought in the Bahamas. As such, the count of the complaint of loss of consortium was dismissed. However, for the defendants, their attempts to dismiss the complaint against Amy Howard is based on A, the forum selection clause, and B, the federal doctrine of forum nonconvenience. As the forum selection clause, the court reasoned that the complaint could not be dismissed as it relates to Amy Howard under the forum selection clause because, based on the affidavit that were filed with the court, Amy Howard did not sign the guest registration forms, although Amy Howard has stayed at the Atlanta resort on two prior occasions. On both occasions, she did not book the trips. As such, she did not have an opportunity to review the forum selection clause on either stay. And no documents have been produced by the defendant that demonstrate that Amy Howard has in fact been provided with a meaningful opportunity to review the forum selection clause and assent to the provision. Additionally, in this instance, Mr. and Mrs. Howard did not make the travel arrangements for themselves. Their first opportunity to review the forum selection clause was at the resort, and it was the husband, not Amy. So he's the one that signed the documents. As such, the court concluded that Amy Howard was never given prior notice to the forum selection clause. As for the federal doctrine of forum nonconvenience, this doctrine, this is a dismissal under this doctrine. Dismissal is appropriate when a three-prong test is met. It is important to note that all three prongs must be met by the defendant. First, the court must consider whether an adequate alternative forum exists that has jurisdiction over the case. Second, the court must consider whether private interest factors suggest that the court should disturb the strong presumption in favor of the plaintiff's choice of forum. And third, if the court finds that the private interest factors are indeterminable, the court must then proceed to consider whether the consideration of public interest favor a trial in a foreign forum. Also, an adequate alternative forum. The defendant's submission to the jurisdiction is an alternative forum renders that that forum available for the purposes of a forum nonconvenience analysis. The defendants are a Bahamian corporation. They have stated that they are amenable to service of progress in the process in the Bahamas, and the Bahamian legal system recognizes negligence actions as such the ones presented by Amy. Additionally, courts loath to hold another forum is inadequate, finding the first prong of the doctrine has been met. Also, private interest factors. The analysis begins with a strong presumption against disturbing the plaintiff's initial forum choice. This presumption will only be overcome with positive evidence of unusually extreme circumstances, and the court must be thoroughly convinced that the material injustice is manifest. Also, the defendants argue that the vast majority of evidence is located in the Bahamas. Court reasons that the majority of the documentation and other evidence can be obtained and made available within the Southern District of Florida. Defendants also argued that access to witnesses and the ability to compel attendance at trial will be proven difficult. Court reasons that 9 out of the 13 witnesses are employed at Atlantis and they can be compelled to testify. The remaining third-party witnesses, fish vendors, while they may not be compelled to testify, this in and of itself is inefficient to overcome the strong presumption in favor of the plaintiffs and of their forum choice. The defendants have failed to demonstrate that it would be unusually inconvenient or costly to transport their employees to South Florida to testify in this action. Additionally, the defendant fails to meet the burden that live testimony is required from the other witnesses that can still participate in the South Florida litigation through videotape depositions and other forms of discovery that are recognized. Essentially, the defendants fail to testify the second prong. There's also public interest factors. Although the second prong is not met, the court, in the abundance of caution, still proceeds with the analysis of the third prong. The court looks to the fact that U.S. citizens should not be ousted from a U.S. forum. Additionally, the court is mindful of the fact that the part of the reason the defendant wishes to have the matter addressed in the Bahamas is due to the favorability of the Bahamian legal system regarding these claims, as opposed to the thinly veiled convenience that the defendant relies upon. Ultimately, the strongest factor in favor of dismissal is the fact that South Florida residents have little interest in adjudicating a dispute between citizens of North Carolina and the Bahamas. The court does not believe that this reason is sufficiently compelling in and of itself. So, in light of all of the foregoing, it is my position that the court reached the appropriate conclusion based on their application of the relevant case law. It was undisputed that Amy Howard had not been involved in booking any of the vacations that took her to the Atlantis resort, nor did she sign the guest registration forms, which contained the forum selection clause. Without a meaningful opportunity to review the forum selection clause, she cannot be bound by it. Once the forum selection clause language is no longer a consideration, then the analysis shifts to the doctrine of forum of nonconvenience. Under this doctrine, the plaintiff is given a substantial deference when they can select their initial forum. It is important to note that the complaint devoted a substantial amount of time to establish the contact between Plantation, Florida and the Bahamas. The corporations had offices in Plantation. They conducted business in Plantation, and they were engaged to inter- and intrastate commerce here. As a result, it was undisputed that there were sufficient ties to warrant the forum to the Southern District Court to be a consideration. There does not appear to be any dispute raised by the defendants as to that fact. They simply focus on the forum selection clause and that the Bahamas is the best place for this matter to be tried. So ultimately, the defendant proves unsuccessful because although they are willing to accept service in the Bahamas and litigate there, they are unable to sufficiently demonstrate the court's substantial amount of prejudice and material injustice to their position that would occur if they're required to litigate the matter in South Florida. The bulk of the witnesses were employees of the resort, um, and the corporation certainly has the means to transport their employees to South Florida to testify in court. The documents that were provided for review never allege any forms of financial hardship that would prove otherwise for the Bahamian resort company. The defendants simply rely on the notion that they cannot compel them to testify. The court simply does not give merit to their position, seeing as how these individuals are employees of the corporation. Additionally, the 4 remaining witnesses can provide testimony through other means of discovery that are acceptable. So ultimately, at this stage of the litigation, the defendant receiving a dismissal of Kenneth Howard did not substantially assist him when the bulk of the damage sustained were incurred by Amy Howard, not Kenneth Howard. Thank you.